Good afternoon, and welcome to another webinar with Richards and Jurusik Immigration Law. My name is Jeremy Richards, and I'm here along with one of our associates, Rebecca Kroll.
Hello.
And today we will be discussing the exciting topic of L-1 visas for business expansion for Canadians into the U.S. market. And we deal with this all the time. We deal with Canadians who are living in the United States and that want to do business in the United States. And I actually and Rebecca has consultations all the time with individuals in this situation. I had two of them this morning talking with businesses in Canada about their intentions of doing business in the United States and what those options are. And one of the main options that individuals or businesses use for expansion into the United States is the L-1 visa. It's a great option for business expansion. And we're going to be discussing that today. All right, so we're going to cover what is the L-1 visa, what are the benefits of that L-1 for Canadians specifically, what are the criteria for the L1, and then we're going to talk specifically about new office setup and what that looks like through the L1 visa program, the application process and how long you should expect that to take, and then options for family members of L1 visa holders, and then we'll also just introduce you to some upcoming webinars that we have.
So the L-1 visa is a non-immigrant status or visa that allows U.S.-based companies to transfer essential employees from their international offices to come work in the U.S. And this is particularly useful for multinational companies that need to bring experienced executives, managers, or individuals with specialized knowledge about the company to come support operations and lead expansions in the U.S. The purpose is to bring those people in those positions. So we have our executives who they primarily direct the management and organization of the company, managers who supervise and control the work of other professional level employees, and specialized knowledge employees who possess an advanced knowledge of the company's products, processes, and procedures. The goal of this is to allow continuity and growth by enabling these key people to come to the U.S. and support operations and kick them off in the U.S. So the key benefits of the L, it enables companies to move their staff without a lengthy labor certification process. With the L1A, there is also the option to get a green card eventually through the EB1C immigrant visa category. And there's also special family accommodations for your spouses and any unmarried children under the age of 21, which we'll touch on a bit later. Now, for eligibility requirements here, there's a few key conditions that must be met first. So for employment abroad, the employee you're looking to transfer must have worked for the foreign entity of the company for at least one continuous year within the past 3 prior to entering the U.S. Another key requirement is that there's a qualifying corporate relationship. So there needs to be a valid relationship between the U.S. and foreign entities. So that can look like a parent company, branch, subsidiary, or affiliate. But that relationship needs to be clearly documented through the proper business documents there. And it's really valid for U.S. assignment. So the position in the U.S. must require the applicant to continue on in that executive or managerial or specialized knowledge role. Now, for benefits to the U.S. or benefits to Canadians here.
I think I skipped up there. I messed that up. Sorry. So here we are.
There we are. So for Canadians, it's really a streamlined process here. So one of the biggest advantages for Canadian citizens is the ability to apply for the L1 directly at a U.S. port of entry or pre-clearance airport. So this means that you generally will receive a same-day decision, which bypasses that lengthy adjudication process. After you do apply at a port of entry, you're approved, you're free to enter the U.S. and start your employment. USCIS does have final say on that adjudication. That will come in some time after your border application, but it allows an instant decision, which is a significant time saver, especially for executives or managers who need to quickly enter the U.S. to oversee their business operations. Now, unlike the H-1B visa, there is no lottery. The H-1B is capped annually and subject to that lottery, and the L-1 doesn't have that. So as long as you meet those eligibility requirements, you can apply really at any time of the year. There's no limit. And the L-1A is a bit more predictable, and it's accessible for individuals. In terms of business growth, it's the L1 is the ideal option if you're looking to expand in the US market and you have a foreign company with that affiliated relationship. It allows Canadian businesses to send, those key workers to come and grow that US office, which is especially beneficial for those startups or small, mid-sized companies looking to build their international, build their international scale with their company. And again, it is a very family-friendly type status, which we will discuss a little later, but there are L2 visa options available for spouses and children. And lastly, like we touched on, there is a pathway to a green card from the L1A specifically. The L1A is dual intent, meaning that you can apply for that green card without jeopardizing your non-immigrant status. L1A holders, you're transitioning to the EB1C immigrant category when you apply for that green card. And that category is specific for multinational executives and managers. And that EB1C route does bypass that traditional labor certification process that takes years and years and seemingly drags on forever. Now, for Canadians to be eligible for the L1, so we kind of touched on this, so there needs to be that qualifying relationship between the Canadian company and the US company. So parent subsidiary relationship, an affiliate, or a branch company, those all qualify. That also means that there needs to be common ownership and control. So, for example, a Canadian parent company setting up a US subsidiary, or two companies under the same ownership umbrella. There needs to be that majority connection. And it's important that this relationship is clearly documented through corporate ownership records, such as organizational charts, operating agreements, or share certificates, and what have you. Border officers need to see that documentation, and so does USCIS, to prove that that relationship is legitimate and ongoing. For business operations, the Canadian entity needs to have been operational for at least one continuous year prior to the application. This is what shows that it's a real and functioning business and not just a shell company created for immigration purposes. And the US office must either be already actively operating or in the process of being set up. So for new offices, you're not going to be that established, but this could mean securing a physical location, opening a US bank account, and starting to outline a business plan for the coming years. If the US entity is still being established, that is when applicants would qualify for a new office L1, and that comes with some additional documentation requirements, which Jeremy will discuss shortly. And for the employee, the applicant themselves, they need to have worked full-time for that Canadian company for at least one continuous year within the last 3 years before entering the US. The nature of the position does matter. It needs to be in that managerial or executive capacity. And same for if you're going for the L1B with your specialized knowledge, you need to continue on in a similar capacity in the US. So that role needs to match the qualifying category that you are falling under.
Okay, so if you are setting up a new office, now this is assuming you do not have US operations yet. And like Rebecca said, before you do this, you have to have an active operating Canadian company. And by definition, that means it has to be at least 12 months old. And you have to have certain things in place in the United States in order to facilitate this transfer. Now, for Canadians, this process is simplified. You can skip U.S. Citizenship and Immigration Services with these filings. Most foreign nationals have to get approval through USCIS before they do this process. But Canadians can do it straightforward at a port of entry as long as you meet these preliminary requirements. One of the most important ones is an office space for your operations. And they have a specific definition of what an office space is for L-1 visa purposes. And they say that it has to be sufficient to support the successful operations of the business. Well, what does that mean? Well, that physical location varies depending on your business type. If you're coming and you're opening a manufacturing facility in the United States and all you did was lease a 100 square foot office space, that's not going to support a manufacturing business. They expect you to have a facility that can support all of the equipment and everything that's going to be required to run a successful manufacturing company. Earlier today, I talked to a trucking company, and they want to expand into the US. Well, for that type of business, they're going to expect you to have a place to park your trucks. They're going to expect you to have a garage to fix your trucks. They're going to expect you to have an office where you're going to do dispatch out of. So the space that you acquire in the United States when you're expanding has to be sufficient for your type of business. Now, you don't have to start full scale, but it has to, at a minimum, be able to support those operations from the beginning, and you can expand from there. And that looks very different for whatever type of business that you're doing. But for L-1 visa purposes, a physical location is mandatory. It's something you cannot skip. You need to be careful with the type of office that you choose. If you're working with a Regis, for example, that can be a red flag. You see a lot of individuals, they'll just do a lease at a Regis where it just gives you an office address and a phone number, but there's no actual office space. That's not sufficient. You need to actually have office space as a floor plan that details your office. It has a desk and it has a sign and it has its own specific suite or address. That's what they're looking at. So if the way I say it is if USCIS investigators coming to verify that your business is operational, are they going to be able to look up that address, go to your door, ring the doorbell or knock on the door, and it has your sign on it? And when that door opens, then one of your employees would answer. That's what they're looking for. They have to track you down, find your business, and verify that this is an operational business. Also, you need to have a business plan. Since it's a new company, it's much like getting a loan from a bank, right? You're operating on your potential. So they want to see, and we recommend at least a 3-year business plan detailing the growth that you expect over the next 3 years. And one of the most important aspects here is demonstrating that this company is going to hire employees and it's going to grow to be able to support a permanent full-time manager in the United States. If you're coming in on L-1 purposes, you have to demonstrate that this is an executive or managerial capacity position. And if you don't have employees, you're not going to be able to demonstrate that. So showing the growth potential of the company to get to the point that it can support a permanent full-time manager. Now, you can also do business expansion on an L-1B, and the requirements do shift a little bit. The requirement for managing individuals doesn't exist when it's an L-1B. That's specialized knowledge. So it's not as important in that situation. What's important there is actually doing business. So the business plan should detail this, those projections, how many employees you're going to be hiring. Also, when you do this, you have to have that related entity formed before you apply. So as Rebecca was mentioning, that the affiliate, subsidiary, or whatever it is that makes sense when you're working with your business attorney, that has to be set up too. So you have to have the physical office space set up, but you also have to have that formation done. So the affiliate, relationship, subsidiary, whatever it is that you decide is best for your company in the United States. And when you form that, you're also going to be assigned what's called a federal employer identification number. That allows you to do business in the US and allows the government to take taxes from you. That's really what that is. So it's your employer identification number. Those are the basics for the US entity. Everything else is going to be coming from the Canadian entity. And as Rebecca said, you need to have a year's worth of records, payroll records, tax records, invoices, a lease agreement, everything showing that you're active operating business in Canada, along with these preliminary requirements in order to do a new office in the United States. One of the downsides to this is it's only approved for a 1-year time period initially. And they do that because, again, they're operating on faith here. They're operating on you coming in and actually doing business, servicing clients, hiring employees. So that's why they limit it to a year. Then you have to go back at the end of that 1-year time period and demonstrate, hey, look, we have X amount of employees on payroll. We are generating this amount of revenues per month, and we're providing whatever service it is that you're providing, and show that you're active and operating at that point. And then they will extend your visa. So that initial visa is limited to a 1-year time period. So very important to understand. And it's a short time frame. So before you apply for that L, you better have everything in order so that when you get that visa, you can hit the ground running. So the application process for a Canadian is streamlined. It's simplified. So once you determine you have the qualifying relationship, what the qualifying role is, and that you have that qualifying U.S. operations, then you would assemble all of the documentation in support of both the Canadian and U.S. operations, and that includes proof of the qualifying relationship, so the registration documents showing what percentage of ownership, the percentages of ownership in both the Canadian and U.S. company. And the most important thing there is control. They have to be controlled by the same individuals or entities to demonstrate they qualify. So control is very important in that relationship and maintaining the same control between both entities. And then your business plan, your proof of office space, and then for the individual being transferred, you're going to have to demonstrate that they have worked in that executive, managerial, or specialized knowledge capacity for at least a year, that they've been on payroll for at least a year. Now it can be a little bit more complicated. If you're an owner, then there are other things you can use as proof of your 1 year of employment, and that they will accept if you're not taking a weekly paycheck, for example, maybe dividends or whatever else you might receive as far as compensation. And then detailing the job duties and demonstrating that not only was the job in Canada an executive or managerial position, because you have to show that the person held that type of role before being transferred, and that they will also be holding that type of role in the United States, or specialized knowledge. If that's what you were in Canada, you have to demonstrate it'll also be specialized knowledge position in the United States. Once you've assembled all that documentation, I mean, Rebecca can speak this too. I mean, these are usually several inches thick. These are not small applications. They still do them on paper. And these applications you'll take directly to a port of entry or pre-flight inspection point, and they're presented in person. And typically the interview takes, I would say, 30 minutes or less. It can take longer if there's a wait or the officer's taking their time, but it's a fairly straightforward process with the proper paperwork. And you show up to the port of entry, they will review all the documentation, they will verify that all the criteria are met, and then they will admit you in L-1 visa status at the port of entry. Now, in some instances, that's not an option. There could be complicating factors, but typically we recommend port of entry processing because it's much faster and less expensive to do that. After the border receives the application, they will admit you in L1 status, and they'll give you what's called an I-94 record of admission, but they will still send that application to U.S. Citizenship and Immigration Services, who will then eventually do final processing of that, and then they will issue a final approval notice that will arrive by mail showing that both CBP and USCIS have approved the application. And it can take several months to get that back from USCIS. And it's not necessary to receive that prior to working. Once CBP admits you, you have been approved. The USCIS approval of it is a formality at that point. All right, so renewing and extending. So there are time limits on the L-1 visa. For an executive or managerial role, the L-1A, it is a 7-year maximum. And for the L-1B, it's a 5-year maximum. And typically, if you're starting again with a new office, you're just going to get 1 year to begin. And then they'll fill it in with 2. It could be a 3-year and then a 2-year approval. Am I doing my math right? No, that was bad math. If it's a 5-year, you'll get a 1 year up front for L-1B, then 3 years, and then your final year is how they'll do it at the border. If it's for an L-1A, they'll give you 1, then 2 3s to meet your 7 years. Now, that's if you are working in the United States on a full-time basis. If you're not in the United States on a full-time basis, maybe you're intermittent or part-time and you're spending less than 50% of your time in the United States, it is possible to receive unlimited extensions of an L1 if you meet that part-time or intermittent criteria. Then that allows you to keep extending the L1 visa as long as you're needed in the United States. So extensions beyond the initial L do depend on several factors. How much time are you spending in the United States is one of those key factors. And it requires proof that the businesses are ongoing, that the Canadian company and the US company are doing business, that there are employees on payroll, that you continue to meet that executive, managerial, or specialized role. And if you demonstrate that, then you would be able to continue to receive those extensions. And if you meet the intermittent or part-time in the United States, spending less than 50% of your time in the US, Canadians could take advantage of doing these extensions at the border. Huge advantage for Canadians. However, even if you're Canadian and you're spending full time in the United States, and this is very important to remember, if you are full time in the US or spending more than 50% of your time per year in the United States, then you no longer have the ability to do these extensions at the border. You would have to then extend that by mail with US Citizenship and Immigration Services. So very important to keep in mind. Typically when someone's doing an L1 expansion and it's a new office for 1 year, we tell them to mind their time in the United States so they can at least get that 3-year extension at the border and forego filing with USCIS, because Rebecca can attest to this too. USCIS and their adjudication standards are up here compared to CBP. So if you want to maintain that ability to work with CBP, you have to be spending less than 50% of your time in the United States to preserve that.
Now, the L1A is really a very family-friendly option for your dependents. So your spouse and your children under the age of 21 can get an L2 visa, or for Canadians, an L2 status. You guys are eligible to apply right at a port of entry. It really just is a matter of proving the relationship between yourself and the principal L1 applicant, showing that they've been approved. And of course, having your passports to show that you are also Canadian citizens. That's one thing that's important to keep in mind. Only dependents who are also Canadian citizens can do that at the port of entry. That L2 status allows your dependents to enter and remain in the US for the same duration as the L1 visa holder. And if you need to renew, if the principal L1 holder renews or extends their L1, then the L2 status can be renewed as well or extended. Spouses on that L2 status enjoy unrestricted work authorization in the US. So that work authorization is incident to your status. There's no separate work permit required that you need to apply for. Really, as soon as you're granted that L2S status and you obtain a social security number, you're free to work. Spouses can also enroll in school and pursue that higher education if they wish. And for the children, they can enroll in school as well. They don't need a separate student visa like the F1 in order to do so. But it is important to note that L2 children are not eligible to work, unlike the spouses. Once those children do turn 21, they no longer qualify as dependents. So if you have a child that's kind of on that borderline there, they would need to transition to another status when they turn 21 if they wish to remain in the US.
Perfect. All right. Let me get here. So hopefully this gave you a good overview of the L-1 visa for Canadians looking to expand into the United States on what we call a new office visa. It's an excellent option. For a Canadian, it's a streamlined process, can be done at the port of entry. And for those individuals who want to make a permanent move to the United States, then it has that pathway to a green card. And in our upcoming webinar, we will be discussing that pathway specifically, how to go from an L-1 visa to a green card for executives and managers that fall into that situation. And then after that, we will move on and we will begin discussing E1 and E2 visa options for investing in the United States, as well as those who conduct trade with the United States. They do the majority of their business in the United States. If you have any other questions about U.S. immigration, well, Rebecca, me, anyone in our office, that's what we do. U.S. immigration, specifically for Canadians. The QR code in the corner, you can register for these upcoming webinars, but you can always reach out to us through our contact information. So give us a call, visit our website, or scan the QR code to get our contact information and reach out to us directly. We'd be glad to assist you with your U.S. immigration needs. Thanks for tuning in and attending this webinar, and we look forward to meeting with you again next time. Have a great day.